We talked for a second about pre-trial detention. A federal magistrate judge once said to me, Mr. Passon, you've never met a client you didn't think should be released pre-trial. And even though that was his condescending way of calling me a bleeding heart liberal, I wear that statement like a badge of honor because, for the most part, it's absolutely true. I do believe that. Why? Well, first of all, there's something called the presumption of innocence. When you detain someone in a shitty jail pretrial, you have just sentenced them without them having been convicted of any crime. Let's face it, it's usually the poor who rot in jail waiting for their case to be resolved. And some of them are actually innocent. And the conditions are typically terrible. And the bigger problem is it hinders their lawyer's ability to mount a defense. It's much harder to communicate with counsel, review discovery, and do all of the things necessary you need to do to work on your case and prepare for trial. And guess what? Prosecutors love pretrial detention. They don't really believe that a person is a flight risk or a danger in many cases. They just want them in jail. A, to suffer, B, to control them, C, to gather extra witnesses and evidence in their case. They can record all the phone calls of a defendant sitting in jail. They can coerce plea bargains out of them because many defendants will admit to things they didn't even do just to get the fuck out of whatever hellhole they've been rotting in for the last 6 months or a year or 2 years. The truth is, pre-trial detention should be reserved for only the worst of the worst, those people that actually present a clear and present danger, real danger to the public. But that's not how it works, especially not for people with no power, no privilege, and no resources.